Hello, and welcome to Module 5, Trial Preparation and Readiness, Subpoena section of the ULV Justice Center website. Glad to have you. Before we get started, please be aware the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. This is the last section in Module 5. You've learned about witnesses, exhibits, trial brief, trial binder, and now I'm going to cover subpoenas. In this section, I will be discussing where you are in the process, what is the purpose of this step, what do you need to accomplish during this step, who do you need to send this to, when do you need to send this, how do you need to send this, and what is the timeline of and what is expected to happen next. Where are you in the process? At this point, your lawsuit or your response has been filed. Discovery should already be completed, and it's now time to prepare for trial and get your subpoenas issued. A subpoena is a court order issued at the request of a party that requires a witness to testify at a hearing or trial. If you have discovered another party has testimony or documents that are going to help your case, you need to use a subpoena issued by the court clerk. What is the purpose of this step? During the discovery process, deposition subpoenas are often used to get testimonial evidence or obtain documents and records prior to trial. Subpoenas may be used to require someone who is not a party to the matter to appear personally and/or produce specified evidence, such as documents or business records. What does a court consider evidence? Evidence is information you may present in court to prove your case. It can be in two main forms. The first form, people, witness testimony, you or other people who have direct and relevant information about the case. The second form is things, exhibits, photographs, police records, medical bills, other documents or things. In either case, the judge will want to know why is this witness or exhibit helpful in deciding your case. You will use a civil subpoena for personal attendance to compel the attendance of a witness to appear at trial. A civil subpoena ducis tecum is used by a party who has failed to request certain essential or critical documents during the discovery phase of the litigation process, and the existence of those documents is known and the document can clearly be identified. Then a party can prepare and serve the subpoena on the other party to bring the papers and testify, or just bring the papers. You must understand that there are rules of evidence that everyone must follow. These rules help ensure that the judge gets reliable, relevant, and accurate evidence to consider when making decisions about your case. Among the most important of these rules are that generally, people can only talk about what they know firsthand, what they themselves have saw, heard, felt, smelled, or tasted. There are some exceptions to this rule. Understand that the other party has a right to cross-examine anyone whose words, whether written or spoken, are being considered. All testimony must be relevant information. Also note that different case types have their own rules. For example, how long you have to do things or how many questions you can ask. These are ruled by case type. You can find this information under the link Getting Evidence for Court. What do you need to accomplish during this step? If you have a scheduled hearing or trial, the other party may choose not to go. If the party has an attorney and the attorney can attend for his or her client, if the other side doesn't want to show up, or just his or her attorney appears, the judge cannot make him or her testify nor consider documents that may be only in that party's possession. Sometimes You may want the other party in your case to be present in court. For example, you may want the other party to testify in front of the judge, or you may want him or her to bring certain documents to the court because they will help you prove your case or give you information you or the judge will need. If this is the case, you may need to make sure that the other party in your case actually comes to court so that the judge can order him or her to testify or produce the documents you need. Who do you send this to? Witnesses you need to prove your side of the case should always be served with a subpoena to appear so that their employers will allow them to leave work to come to court. If the other party is represented by an attorney, and that attorney has authority to accept service, it may be served upon them. The only way to properly serve a party not represented by an attorney is through personal delivery. A subpoena must be served personally by someone over 18 who is not a party to the lawsuit. You may not serve the subpoena yourself since you are a party. You can use a sheriff or professional process server, but it's easiest and least expensive to use an adult friend or family member. You can access this information for free on the web page. Just click on the Service of Process link. The person who serves the subpoena must then fill out and sign a paper describing the service of the subpoena. A sheriff or professional process server usually provides the proof of service form as part of the service of the person. You can fill in the caption for the server, but he or she must complete the rest. After you get the completed form back, make a copy for yourself and save the original to bring with you to court, along with the original subpoena, in case the witness does not come to trial or bring the requested documents. If you use a sheriff or professional process server to serve the subpoena, there is a charge for service. Check with the server first to find out the amount of the charge. If you are asking that a witness bring documents, pictures, or other evidence, the witness may ask the court to make you pay reasonable costs of getting or copying the documents or other evidence. Witnesses can, by law, request witness fee for attending the hearing or trial. You can find this information under the link GOV section 68093 on the webpage. Your expert witnesses, such as counselors, doctors, or therapists, may require you to pay them for their time at their usual hourly rate if they must testify. You will need to negotiate this with them ahead of time. You should also remember that your hearing or trial may not begin at the time it is scheduled. You may want to make special arrangements to notify them by telephone when the trial starts and give them a better estimate of when you will actually need them, or you may want to send your witness a letter or note explaining that there may be a delay in putting them on as a witness if the hearing or trial does not start on time. If requesting records or documents, you as the subpoenaing party must, prior to the specified date for production, serve on the consumer whose records are being sought the civil subpoena duces tecum, the affidavit declaration supporting the issuance of the civil subpoena, and a copy of the notice to consumer or employee. Free access to the form Notice to Consumer is located on the Forms Template section. For free access to the step-by-step instructions, click on the link Filling Out the Forms on the website. This is very important. The law gives the consumer or employee the right to object to the witness giving you records if it would violate their privacy, so you must let them know ahead of time. The links in this section will give you a greater understanding of how to fill out and serve the forms. And the last link, I know it's a few years old, but it should provide free access to detailed information on non-party disclosure. When do you send this or file this? For the notice to attend, not including the request to bring documents, if it is delivered in person, it must be served at least 10 days before the court date, and you must have it served by mail at least 15 days before the hearing date. For the notice to attend and bring documents, if it is delivered in person, it must be served at least 20 days before the court date, and you must have it served by mail at least 25 days before the court date. Service of the civil subpoena duces tecum on the consumer is made as follows. Personal service or by mail to the consumer's last known address or on the attorney of record and not less than 10 days prior to the date of production, plus the additional time provided in CCP Section 1013 and at least 5 days prior to service upon the custodian of records. How do you send or file this? Prior to the production of records, you have to serve the witness with the proof of service stating that the consumer has been served, or furnish the witness a written authorization to release the records being sought, signed by the consumer or his attorney of record. Therefore, prior to the date of production, the notice to consumer or employee of the subpoena for personal records shall be given notice as follows. Every copy of the civil subpoena duces tecum and affidavit served on the consumer or employee or the attorney shall be accompanied by a notice indicating that the consumer's records are being sought from the witness named on the subpoena. Then you have to serve the witness with the proof of service stating that the consumer has been served, or furnish the witness a written authorization to release the records, signed by the consumer or employee or his attorney. The person who's serving you your documents must complete a proof of personal service. Free access to this form is located in the Forms and Templates section. There is a link for how to complete the proof of personal service linked on the website. Please understand that if you are looking for telephone records, a proof of service is not sufficient to obtain. You must have a consent to release such records as required, which must be signed by the consumer and not the attorney. What is the timeline of and what is expected to happen next? You can get your trial continued or postponed if a witness fails to appear in response to a subpoena. A person who disobeys a subpoena can be immediately punished by the court for contempt, including 500 monetary sanctions, plus other expenses caused by the failure to comply. The other party or witness has a right to object to the subpoena. If the party objects, they must file an objection with the court within 5 days, explaining why or what they are objecting to. If the parties are not able to reach an agreement to change the language of the subpoena, he or she must file a request for order to quash the subpoena. If the motion is filed by the objecting party, the witness shall not be required to produce the records, except upon order of the court. If the witness is a non-party, he or she has the right to file and serve written objections. And then it becomes your obligation to seek a court order for the non-party witness to comply with the subpoena. A party requesting consumer, personal, or employee records must bring a motion to compel under CCP Section 1987.1 within 20 days of service of written objections in order to enforce the subpoena. All of these documents will need to go into your trial binder. For free access to getting evidence for court, click on the link on the website. This has been an overview of subpoenas, completing Module 5, Trial Preparation and Readiness. On behalf of the ULV Justice Center, we thank you for your time and hope this information is helpful in your legal matter. And remember, the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney.